Let me paint you a picture. It's spring, and we're getting ready for spring's work. The weather is finally warming up, the grass is getting green, and the robins are back. The equipment has been serviced and is ready. The seed and fertilizer has been bought. The bills are coming in. The livestock still needs to be fed, and the door slams in your face, and your husband has a stroke and dies. Wow. Everyone in the community says the same thing. Well, she'll handle it. She knows the operation. She's been working with him for quite a while now. And maybe she does. Maybe she knows every field by name. Maybe she knows which bin the grain is in. Maybe she knows which mechanic can fix the sprayer or calibrate the air seeder. Maybe she knows what has to happen this week, today, or this afternoon. But what if the operating account is only in his name? What if the line of credit is only in his name? What if the trucks and equipment are only in his name? What if the machinery, the paperwork, the notes, the grain checks, the leases, the whole paper trail, what if it all points back to one person who is no longer here? Then her husband dies unexpectedly at the exact same time as spring's work. And suddenly, the question is not just who gets the farm someday. The question is who has the legal authority to keep the farm running this week? Because knowing how to run a farm and being legally authorized to act for a farm are not always the same thing. For sole owner assets, banks often require estate documents before funds or authority can even be released. And when someone dies with a will, the court may appoint an executor with letters of testamentary. Without a will, the court may appoint an administrator with letters of administration instead. And that is what I want to talk about today.
Welcome to the Pathfinder Legacy Podcast, where we help farmers, ranchers, and business owners create a seamless transition plan for the future. From retirement to ownership transfer, we protect what you've built and guide you every step of the way.
Hello, all. Welcome back to the podcast. Since April is recognized as National Financial Literacy Month, I wanted to spend this episode on something that does not sound exciting. It's not sexy, but hey, it can change everything for a family and especially for a farm family. Today, we're talking about probate, why a will matters, and why not having a plan can leave a spouse and children trying to mourn a death while also trying to hold together a business that never gets to stop. Because as we all know on a farm, death is not only personal, it's personnel, operational, financial, and legal all at the same time. So let's start with the basic question that I get frequently. And if you haven't been through it with your parents, grandparents, extended family, you have absolutely no idea what it is or what to expect. So first off, I want to make this clear. If you have a power of attorney for someone, note that ends at death. That is often confused with personal representative. A power of attorney ends at death. A personal representative is who is appointed to handle someone's estate. What is probate? Probate is the court-supervised process of sorting out someone's estate after death. In plain English, it is the legal process for recognizing a valid will, if there isn't one, identifying probate assets, appointing the person in charge of the estate, paying what needs to be paid, and distributing property under the will or under state intestacy laws if you pass away with no will. Probate assets are generally the assets held in the deceased person's sole name, and does not have a survivorship feature or beneficiary listed that moves them outside of probate. That means probate is not automatically a sign that someone did something wrong. No, probate is just the legal lane for certain assets. But where people get into trouble is when they assume my spouse knows what to do, so everything will be fine. My kids know what I want, so that should be good enough. No. Knowing your wishes and having legal authority in today's world of business are two completely different things. And on a farm, that gap can be a huge disaster. Because the farm does not pause for the legal paperwork. The cows don't say, take your time whenever you're ready. The seed dealer does not say, no rush on paying me. The landlord does not say, don't worry about the lease payment this year. We'll figure it out next year. The combine doesn't say, we'll revisit this after probate. No, everything has to keep moving. And that is why this matters so much in our farming operations. In my experience, farms often have untitled assets like machinery, equipment, livestock, crops, grain, and that probate can be problematic for timely management decisions such as buying and selling and trading equipment. The more complex farm plans often need more than just a basic will because untitled or overlooked assets can still end up controlled by probate. So when people say, what's the big deal? The wife will just keep running it. You're going to hear this theme many times throughout today. Yes, maybe eventually she'll keep running it, but not always immediately. And on a farm, immediate needs matter because if everything was in the husband's name, the surviving wife may not automatically be able to access every account that is just in his name. She can't transfer every asset or sign every piece of paper the minute after he dies just because, everyone knows that she's his wife. But in many cases, the estate representative has to show formal authority to act. And depending on the state and the estate, getting that authority takes time. So when I was working at the bank, my experience, it took anywhere from 9 months to 2 years to complete a probate, depending on the amount of assets and the complexity of the estate. In some jurisdictions, it may take weeks or more just to issue the court papers authorizing the executor to be able to work on this estate. It's often up to the court schedules and how many judges are available to hear those hearings that week. Now, let me be clear, because I do not want anyone to hear me saying something I'm not saying. I'm not saying the wife doesn't have rights, and I'm not saying she doesn't get shut out forever. Many states protect surviving spouses in various ways. And a spouse may inherit under the will or under the state's intestacy rules. Now, that's if you have no will, but she may inherit is not the same thing as she has immediate authority over every solely named asset in her deceased husband's name that week. So those are different questions. And that difference is where families get blindsided. I've seen enough farm families and heard enough stories to know the pattern. A husband dies, and everyone just assumes the surviving spouse can just slide right into place. But then Monday comes around, and the bank wants documentation. Who's got authorization to operate these accounts? Because he's deceased. The grain buyer wants documentation. Accounts get frozen. Some title for equipment needs to get transferred. And decisions need to be made. There's bills that are due. And there's a piece of paper that matters now because this person whose name was on everything is gone. And all of that is happening while the family is still in shock. They're still mourning. That's why I say probate is not just a legal topic on a farm. It's a business continuity topic. It is a cash flow topic. It is a can this place function next week topic. And this is not why a will matters. A will is the document where you state your wishes for your probate assets, name the person you want handling the estate, and if you have minor children, nominate the people you want to raise them. A will can let you designate an executor and nominate a guardian for your minor children, helping reduce that uncertainty and court involvement. But here's the part that people miss. A will matters a lot, but a will is not the complete plan. Because your will generally governs probatable assets, it does not control property that passed by beneficiary designation by titling. If you have jointly owned property, maybe it's a checking account that's jointly owned with rights of survivorship. Maybe it's a life insurance policy with named beneficiaries or retirement accounts, 401ks, or IRAs with named beneficiaries, and some assets with pay on death or transfer on death features. So saying this as much as possible in plain English, I would say it like this. A will absolutely is essential, but a will by itself does not magically fix bad ownership structure. So if the farm checking account is only in one name, that matters. That's a huge problem. If the land is titled in a certain way, that matters. If vehicles are in one name, that matters. If the life insurance beneficiary is outdated, that matters. If grain, livestock, and equipment are untitled farm assets with no bigger plan around them, that absolutely matters. That is why families can have a will and still have a complete mess on their hands, because the question is not only, do you have a will? The question is also, how is everything owned? How is everything titled? What has a beneficiary? What is still going to get stuck in all of this red tape? And who can legally act right away if the owner dies? Those are different questions, and they all make a difference. Let me give you a couple of real life farm examples, because sometimes this topic gets pushed down the road for a rainy day all too often. Picture a farmer who died in April. All right, we're coming on April here pretty soon. He handled the operating note and annual renewals with the lender. He signed the crop input checks. His name is on the grain contracts. His wife doesn't know all of these details. She only sees the cold side. She knows the seed is purchased, what acres are being planted, who the landlords are, and the timing of everything. But now she's standing in the middle of planting season with grief in one hand and paperwork in the other. And she's finding out that everyone knows she's in charge is not the same thing as every banker, every seed dealer, the agronomist, recognizing that she has legal authority today to act. And that is a one-of-a-kind probate problem. Now picture harvest. A farmer dies and the grain is still in the bin. There are still decisions to be made about selling that grain. There are bills that need to be paid. There's labor to coordinate to get the grain to market. There may be equipment to repair or replace before winter comes. And that is exactly the type of moment where these delays become more than just annoying. They become very expensive. They become operational. They become the kind of problem that has a ripple effect across the whole entire year. That is why farm transition source emphasize that probate can interfere with timely management decisions, and why untitled farm assets create special planning headaches. And this is where people say, what should we do? What should a family do? At the broadest level, here's the answer. You need a plan that matches the reality of how your farm actually runs, not how you imagine it runs, not how your dad did it in 1978. That's in the past, not how everybody assumes it works. As I've said before, to assume makes an ass out of you and me. So watch your assumptions, how the farm actually runs, who is signing, who owns what, who has access, who has authority, and who can step in at the right time. What happens in week one? Not in the first year, but week one. Because when a death happens on a farm, the first question is not just inheritance. The first question is continuity. Can the spouse pay the bills? Can the operation keep going? Can livestock be managed? Can necessary decisions be made? Can the farming operation move forward to continue the business? That is why some families use a mix of tools instead of relying on one document alone. Depending on state law and the family's goals, property may be set up to pass outside probate through joint ownership with right of survivorship. Beneficiary designations, pay on death or transfer on death designations, or trust-based planning. Farm planning sources also say that trust or entity planning is sometimes used because many farm operating assets are untitled and harder to move outside of probate with simple beneficiary designation alone. Okay, so now I got a story. So I worked with an estate where the landowner died, and shortly after he passed, the farm tenant also died. It was the husband, so he did all of the farming. While I was getting farmland ready to sell for the landowner's estate, I discovered that there was a grain bag full of wheat stored on this property. It had to be removed before I closed on the land sale. I went to the widow of the farm tenant to talk to her about removing the grain. Well, it took her a while to return my phone calls. She was still grieving. When she finally called me back, she didn't want the grain, and by this time, it had been stored in the bag on the field for 2 or more years, and she couldn't do anything with the grain as wildlife got into the bags and it was all rotten. So by her not doing anything with the grain, she lost approximately 60 to 70,000 in income, and I had to find somebody to remove the rotten grain and clean up the bag. Luckily, the trucker that I found did it just for the grain, which was barely good for feed. Now, I want to pivot for a minute to the other reason why a will mattered so much to me and my husband personally. For me, the first time this became very real was not because I was thinking about tax strategy or legal theory. It was because Kirk and I were traveling for the first time, and we had to answer the question that us as parents don't want to answer. If something happened to both of us, who would raise our girls? That is when having a will stopped sounding like some fancy legal thing for rich people that you might see on TV. It became a parenting issue, a family issue, because once you have children, you realize very quickly that estate planning is not only about who gets what, it's about who gets them. And that is a different level of seriousness in my eyes. Our parents were too old on both sides to start over raising young children. Some of our siblings had their own kids and their own full, complicated lives. Some simply were not in a position to take on little girls, and some were not people we could trust to raise our daughters the way we wanted them raised. So we had hard conversations, not cute little conversations on the sideline about these cute little girls, and not theoretical conversations, but hard conversations. Who would really parent them? Who would not just feed them and keep a roof over their head like a dog, but truly raise them the same way we were accustomed to raising our children? Who would protect them? Who would teach them? Who would love them with stability and no drama? Who would treat them like daughters and not like burdens? And for us, that meant talking to friends about becoming guardians. That is important because I think a lot of people assume that the answer has to be blood relatives. Well, yeah, sometimes, but sometimes it's not. Sometimes the best guardian is the person who shares your values and your priorities and your view of what childhood should feel like. And here's where I'm going to say something uncomfortable, because real estate planning conversations are absolutely uncomfortable. Nobody ever wants to talk about this stuff, but not every relative is the right guardian just because they're family. Some people do not have kids and really do not know how to parent. Some people are too overwhelmed with their own life. Some people are financially reckless. We've seen them all. Spend with no budget in mind. Some people are emotionally unsafe. Some people may love your children in their own way, but still not the people you would trust to shape their future. And then there's the harder truth. Some people would not see your children clearly. They would treat them as second-class citizens. And this is where I'm going. Some might look at what your children come with. They come with land. They come with assets. They come with insurance. They come with farm property, future inheritance, and see an opportunity instead of responsibility. And I was not willing to gamble my girls on that. I was not willing to have them looked at like a meal ticket tied to the eventual sale of our farm assets. I was also not willing to have them raised in an environment where they felt less than. So, yeah, we had to make difficult choices. And this is exactly why a will matters for parents. A will lets you as parents nominate guardians for minor children and name the person who will handle the estate, rather than leaving those decisions more fully to the court processes and their default rules. Okay, I have another story. This is a life insurance story. I had a client that paid his annual premium electronically. He never received paper copies of his statements, so he was in a set it and forget it mode. He passed away, and when his executor was looking for assets, they found this policy was paid from the checking account, just his checking account. When they reached out to the life insurance company, they found out the beneficiary was his ex-wife from 8 years ago. If you have bills paid automatically out of your account, you need to check those bills often to make sure it's up to date and still fits your estate plan. Don't let your family find an explosion later. Now, here's another line that people repeat all the time. You can just handwrite a will on a blank sheet of paper. Here's the careful version of that statement. A handwritten will, often called a holographic will, is recognized in some states, but not in others. And the requirements vary by state. Cornell's legal reference explains that holographic wills are handwritten wills and that some jurisdictions do not recognize them at all. So the issue is not whether the paper had lines on it. The issue is whether your state recognizes that kind of will and whether it meets your state's rules. So yes, in some places, a handwritten will may count, but no one should hear this episode and assume, I wrote something down, so I'm covered. That's way too risky because the whole purpose of a will is clarification. And if the document itself creates any sort of confusion, you may be giving your family the very mess you were trying to avoid. And that brings me back to the farm. I think farm families are especially vulnerable for putting this off because they are busy and used to handling only what is in front of them. You deal with the weather, you deal with the markets, you deal with repairs, you deal with livestock, and you deal with uncertainty all the time. Of course, it's easy to tell yourself, we'll get to that later, but later is where these stories come from because you are afraid of preparing for your own mortality. Later is how you get a widow who knows the operation but does not have legal access to the operation. Later is how you get kids fighting over land nobody planned for. Later is how you get farm assets tied up with a spouse while a spouse is just trying to keep the place functioning. Later is how a business built over decades can be thrown into confusion by one missing document or one bad ownership setup. And please hear this today. This is not only about wealthy people. This is not a big estate conversation. This is a responsibility conversation, a love your family conversation, protect your spouse conversation, a protect your kids conversation, a protect the farm conversation. So if you're listening today, here's the question I would put in front of every family. Do we have a valid will? If we have minor children, have we named guardians and backup guardians? Who is the executor or personal representative? What is owned jointly and what is owned by one person alone? What accounts have beneficiaries? What assets are still going to probate? If one owner died tonight, who could legally keep this farm running tomorrow? Not emotionally, not informally, but legally. And if your answer is, I'm not sure, that's your sign. That is your sign that this is not finished. Because silence is not a plan. Assumptions are not a plan. Everybody knows what I want is not a plan. And a napkin is not a plan. And the wife will just handle it definitely is not the plan if the paperwork says otherwise. A real plan says, here's who has authority, here's who gets what, here's who raises the kids, here's what stays out of probate, here's what still goes through probate, here is how the surviving spouse gets access, and here is how the farm keeps operating if one owner dies. That is the real planning. That is the real financial literacy, because financial literacy is not only budgeting and investing and retirement. Financial literacy is also understanding what happens when life goes sideways. And on a farm, sideways can happen pretty darn fast. For this financial literacy month, do not just think about your credit score. Think about your will, your guardians, your titles, your beneficiaries. Think about your spouse standing in the middle of a season without you. Would you have grief only or grief plus chaos with red tape? That's the question. Thanks for listening to episode 37. Have that hard conversation. Make the plan. Protect your kids, protect your spouse, and protect your farm. At the end of the day, a will isn't about paperwork. It's about protecting your kids, your spouse, and the farm you've spent a lifetime building. Thanks for joining me today on Pathfinder Legacy Podcast. And if this episode made you think about your farm's future, consider sharing it with a family member. Sometimes the hardest conversations are the ones that matter the most. So keep planning ahead, keep protecting what matters, and keep building your legacy. And if you want more tools and resources on farm succession planning, you can find them at pathfinderlegacy.com. Until next time, I'll see you between the ditches.
Thanks for listening to the Pathfinder Legacy Podcast, where your future is our focus. Be sure to subscribe, follow us on social media, and visit us at pathfinderlegacy.com to start building your transition plan today.